Okay, I will press show my screen. Assalamu alaikum wa rahmatullahi wa barakatuh once again.
Wa alaikum salam wa rahmatullahi wa barakatuh.
All right. I think we've waited enough for others. I think we can actually start. It's 10:14, going to 10:15 now. So we are already 15 minutes behind that schedule. So I welcome you all once again to this third. Our admin, you can start recording now. أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم الحمد لله رب العالمين الرحمن الرحيم مالك يوم الدين إياك نعبد وإياك نستعين اهدنا الصراط المستقيم صراط الذين أنعمت عليهم غير المغضوب عليهم ولا الضالين Amen. Yeah, the topic before us actually this morning is to discuss and do justice to Islamic financial contract and services that are available, although we might not be able to treat all within the 12 hours, 2 hours frame, because one and a half hours is started for discussion, while 30 minutes is for question and answer for one to give understanding, because it's not enough for the discussion to be on from my own side, because I want it to be actually to be effective through communication. So that's why I will expect that feedback. Also, I must say that I also promise those that missed the last class too, that having gone through the video clip, that they should note their questions, whatever they are not clear with, so that can be asked also today, and then inshallah we'll do justice. Without much ado, I will go straight to the discussion of today, which is the Islamic financial contract and services. Just like actually we know that as far as Islam is concerned, Sharia is the guiding principle. Sharia is the guiding principle, for all activity. For all activity as far as actually Islamic finance is concerned. And specifically last week, I discussed that I mentioned it that specifically under Sharia is fiqh and fiqh muamalat, that deals with Islamic financial transaction. Today, we see some of those actually contracts as actually as they actually do come into play. Basically, if you want to define actually contracts, it will actually be defined as okay, that instruments that are being allowed by Sharia for us to actually execute financial transaction between parties as far as Islamic finance actually is concerned. Yeah, can you see my screen? Salaam alaikum. Are you seeing my screen?
Salam.
Can you see my screen?
Walaikum.
Yes, sir, we can see.
Your screen is showing, sir.
All right, good. So, the contract, basically, we have roughly four. We have trade base, we have lease base, we have contract, we have transfer of debt, and then we have leases. Because under Islamic finance, virtually all activity, nothing is being left out, because they don't want to where one party will gain at the expense of the other one. So that's why everything is being adequately actually specified out. That if you are going into actually trade-based contract, that's where we start talking about Murabawa. Start talking about Murabawa. Start talking about Salam, parallel Salam, Istisna, and the parallel Istisna. Then we talk of Tawaru. Basically, Then, apart from trade, we have equity base, which could be regarded as a partnership, which include Musharaka, Mudaraba, and also of actually others. Then we have actually lists, which include actually Ijara, Mutanasiya, Metamaliki. Then also we have services, that is agency services as an investment actually, or you have Duala, which actually is not specified. Anybody that comes on board, once you can show evidence of work being done, you are entitled to actually to the pay. It's not being addressed to somebody in particular. That's what we mean by Duala. So starting from the trade one, which is actually mostly common. Some of us actually must have actually come across it. Maybe if you have engaged with the bank, and if some of us are new, Islamic finance actually is one of the most common one. The first one actually we address actually is Murabaha. They call it cost plus transaction. By cost plus, we mean the cost of the item and the markup, which is the profit, will be disclosed, to the other party. And this something actually will be agreed as before the contract is being actually executed. There are instances where a customer will approach a bank and actually indicates that I want you to actually to buy this item for me, and such a customer actually now indicates, indicate actually by way of promise that okay, maybe the bank does not have actually the item, that I now show actually my intention that okay, I want to buy. So that will now necessitate for bank actually to go and actually to go and buy it, and there are some that will just come directly and they'll be able to now execute that contract. However, just a quick note before going to those actually contracts directly, I see the need when I was preparing this slide that it's essential, for us to have an idea of how contracts are really being formed before we actually go into all those details. I've mentioned the basically 4 types of contracts actually we have. We'll go down into detail. But as a would-be Islamic finance and professionals, I think it's actually ideal for us to know that what do they even call contracts? What are those conditions that must be actually in a contract for it to be valid? What constitutes really actually a contract? So that at least somebody, I expect that after this training, that we should be able to speak actually, professionally and competently that yes, this is what to operate as far as Islamic finance actually is concerned. This is the way the contract actually is being formed. These are the things that must be, be present before we now go into specific contracts. So without much ado, I will first want to I have a slide that says formation of contract according to Sharia, because everything that we do as far as Islamic finance is concerned must be guided actually by Sharia. So based on this laid down actually principle, I said Sharia laid down principle and guideline upon which acceptable contracts are formed in Islamic financial transaction. This led to prerequisites of Sharia contracts, and they include the first one, statement of a contract. Statement of a contract. And every of these pillars, because we call these 3 items, they are pillars, but each of them will have actually their condition to each. What will make them actually valid? By statement, we mean somebody pronouncing actually his or her intention, either to a bank or to a third party. I said, I showed to you, I want to buy this something for you, or things like that. You are indicating actually your intention. And that statement of that contract, because Sharia scholars, they don't want to show where because the state of actual contract is that it should be devoid of ambiguity. We have discussed that one in the earlier actually episode. There should not be gara, uncertainty there. Every party will have information as far as actually that contract actually will agree with actually is concerned. So the statement, that intention actually must meet certain conditions. Then the second actually item, which is the second actually pillar of before a contract could become valid, those 3 pillars must be in place. Although there are certain Sharia scholars, but majority of the Sharia scholars from test literature, Ambali School of Thought believe that statement of contract and its condition alone is enough, for a contract to be valid. But the other Fuqaha, that is Imam Shafi, another actually imam, majority of them actually said all those three things, the three pillars are very, very important. Apart from started statement, the next thing is contracting parties, because somebody cannot just indicate that we want to do this. Who are the people that I want to do those things with? If I said I want to actually to sell a particular product, who am I dealing with? That's one of the premise upon which other scholars nullify the position of Hanafi school of thought. That contracting party and their condition, they are very, very essential. So that at the end of the day, it doesn't make the contract void if those conditions are not met. The person who are doing which is not of age or something like that. Then the subject matter, you are making a statement that I want to do this one. What is that something that you want to do? What is that product you want to sell? Which is subject matter of the contract. That also actually is the condition, and it must be well noted. I will say that I said you can't know that all these conditions are related to each of the pillars, which is the background, then the first statement, then two contracting parties, and thirdly, the subject matter of the contract, which are called Makudi Haleya. Then each of the items, I want us to be jotting down so that at least you can actually appreciate this, because this is more like a foundation. I could have gone directly to just discussing trade peace and everything, but I want you to actually to understand the basis upon which all those things rest, just like what I did last week by first discussing Sharia and fiqh, to know the basis before we now go to actually those principles, so that at least it will sink. Right. From the statement of a contract, and that is conditions that must be met. I said the statement is considered a major pillar in a contract, which is what made Hanafi school of thought to conclude it that as the only pillar of contract. But other jurists, that majority of them find that all the three pillars are essential for effective Sharia. And you will agree with me that it's not enough to make a statement, I want to sell Torchlight to you, but meanwhile, the parties you are dealing with, maybe the person is a minor, it's not a mature person, but once that person actually, is defective, then that contract actually is no longer valid. So that's why actually, the school of actually thought that all the majority of them actually agree that no, all the three pillars are very, very essential. And one of the conditions that comes with the statements that we are discussing as well is that I said in Islamic financial contract, the use of past tense is actually what is actually be allowed, so that to make the contract actually effective once it's been accepted. If I'm actually selling, let's say my glass, I want to sell it to somebody. If I'm actually selling, I will say I sold, as a use of past tense, I sold this to you to that it could come actually effective actually immediately. Then the party, you also, when you are responding, I bought from you, so that at least it won't be as if that somebody that intention is not actually validated yet. Then also too, for every contract, there must be an offer and there must be an acceptance. And quickly I said the offer is being called hijab, that is in Arabic, why acceptance is called qabul. And I said, I give an instance that Sharia actually scholar actually principle actually opine that the offer and acceptance, that confirmation must actually be aligned actually together. If I give an instance, I said I sold my car to you for 1 million naira, and the buyer said I bought for that price. There's confirmation. This is an explicit and real conformity of acceptance to an offer. But there are instances where I can actually indicate that, okay, I sold my car for you for 1 million naira, and the party, who is the buyer, responded that I bought the car for 1,200,000. It doesn't actually confirm actually with what I've actually offered, but they call that one an implicit offer. You call it actually implicit actually offer because it did not decline. But however, if I indicate that I sold my car for you for 1 million and somebody now say I bought it for 800,000, that's a counter offer. That nullifies that. So that means there's no transaction. I hope I'm communicating. Are you with me?
Yes, sir. Okay.
All right, good. Then the third condition under our statement of contract is that is your offer. There must be clarity between your offer and the acceptance. You know, it must be devoid of any ambiguity. You can see the response. Example I give on the confirmation, where I said I sold my car for 1 million naira, but the buyer said I bought it for that price. You know, because the price I mentioned is 1 million. You know, it's not where I'm actually, you know, I didn't actually say, I intend to sell, I want to sell. You know, it's actually definite. You know, so much devoid of ambiguity, just like what the basis we have actually under a Sharia principle that say there should not be uncertainty, so that we will not do the other party that say, is this what you mean? And the other party will not be interpreting that, this is what I meant. No, it should be clear. That's one of another condition. Then also too, another condition is that there must be connection of acceptance with offer. That is, the two must be connected together. And what our scholars actually resolve to and agree actually eventually is that, you know, it might be that it is this morning, for example, I offer you that I want to sell my car for you actually for 1 million. If peradventure we are together, you understand? Okay, that's a session. It's possible for me to have actually said it and say 10:01, but we are still together. Maybe you are still going through that. Is that car? Does it worth something? You understand? You have the opportunity. But by the time you want to depart, that session is being closed, that you are no longer actually being together. You understand everything now? That's at the end of the trading session. You understand? You need to actually make sure that acceptance actually must have actually be offered that yes, do this one. So that you won't be issue of disagreement later, that maybe you have left that place. We did that 10 o'clock, you now call me at 10 p.m. That car you offer to me and this all those something like that. But meanwhile, this car is available for you. You will see by the time we get to the subject matter, it's available for you to inspect, because Islam is it's a religion where everything that we want to do has been spread out, so that it's being devoid of ambiguity, so that the other party, no party will gain while the other party actually will now lose. You know, that we expect you that whatever actually I offer you, you see it, you can examine it. I won't put you under pressure that say no, accept. Since you have the, so after your inspection, you know, you can now say yes, you give me actually connected actually is my the offer actually I'll give to you, but not when you have actually left. You now come back at 10 p.m. and say okay, well, that's when that's you want to actually to accept, or maybe you want to start actually making inquiries somewhere. But however, there are conditions. Say, assuming there were defects that that I'm selling purposely eat from you, and you now discover that we will go into that actually later. You have opportunity actually to claim for damage because you are not actually aware, because it shows that person has sold to you under defection. But basically what we are discussing now personally is that those conditions, you know, that will make a particular statement of contract valid. Then the next one, which is the second pillar, which is the contracting parties. You know, the party in the first instance, I'm selling my car to one of you. I am actually one of the contracting party. Any of you actually is one of the second actually party. So two of us that want to actually know, we must meet certain conditions. I must have reached the age of poverty. You know, you also must have reached the age of poverty. That is, and scholars actually opine that it could be through a natural event. If it's for a male, they say when you have a wet dream, and while for female, when there is onset actually of menstruation, that's okay. Somebody has reached the age of poverty. That person to unnecessarily be able to now differentiate between wrong and right. But however, this could be determined by age too. Certain countries, some say 18 years. In certain climes, they say it's 17 years. You know, that somebody actually is has reached the age of poverty, but they believe that person is already, you know, going to the state of actually okay, and old person who is a person that can actually affect, know what he or she is doing to actually to execute a contract. Then the second one is that both of us must be sane. Either of us must not be sick or must not have and actually not having a sound mind, because at that point in time, if I'm dealing with somebody that doesn't have a sound mind, then there is chances that I might cheat that person. You know, what I'm supposed to have, maybe the car worth 800,000. I said the person told the person actually for 1 million. But because the person is not of sound mind, my just actually know that, okay, I bought, you know. But at the end of the day, that's why I say, I've cheated this particular person. That's why for that contract to be valid, at that point in time, when they are dispute, they will verify that is the person of a sound mind. Then also the third question is that condition is that should be the person is also to age of maturity. You know, that this person, just like what Quran actually says that actually know, and say concerning an orphan, that when you are in charge of the property of an orphan, and if it has not reached the age of maturity, they're good to actually to understand that make sure that that property is well maintained. You are entitled to your little coin by way of out of stations actually allowance, which at which you are doing the run around, but not at the expense of the property. You must leave that property by the time you are adding over to the orphan better than the way you met it. So you don't see that somebody, this person is not mature, who doesn't even have business dealing. It's the same person of you that say, let somebody come and see it, or I have added over your father's property to you. But because it's not mature enough, you now go and call somebody at the behind again. This person doesn't know anything. Go and do that, say actually we do that everything. Today they say that property actually is not been eroded. So they said that person must be of matured mind. You know. Then the third pillar we are discussing actually is the subject matter of the contract, which is the car in this instance that I have actually sold to you. And I said the subject matter must meet the following condition in order to be considered a valid contract under Sharia. First, that subject matter must be suitable. For example, under Sharia, there are some items that are being prohibited. You understand? You can't sell blood, so you can't pork, dead meat. You understand? We cannot actually do it. You know. Then also, the person that is selling it must own it. You know, whatever you don't own, you cannot sell. Even simple law of nature of law, I say no that not about that you cannot sell what you don't own. You know, so then the same subject matter, Dr. Rajali said, must be known to the parties. I can't say I'm selling something to you. You have to mention what I'm selling so that the person can be able to now examine what you are selling actually to. Then also too, the subject matter must be have the propensity actually to be handed over. You know, I should be able to hand over to you. That is not something that I kept it somewhere, but you are. How do you now see what I'm actually selling? At that time you are negotiating. That means it's only me seller that I know the condition on that particular item. They say no, the other party must, you know, be able to hand it over something to that part, except there are some actually instead of actually building, you know, where at that point in time the person actually might be able to see it, but we have constructive actually, you know, ownership, you know, as in okay, the title document actually you do. At that time you might know the house, maybe you are actually discussing, it might be after inspection where you want to go and deal, you know, you might not be able to hand over something actually, you know, instantly at that point in time, you know. Then the subject matter that at that time of the contract must be present. You should be able to view whatever you are selling so that there won't be issue of conflict. Somebody that want to buy a property to go ahead to go and inspect it and note whatever actually, you know, issue was made with that particular contract. So at least for us knowing those basis now, pillars, you know, upon which contract is formed now. So we now want to now go into those contracts in details. Am I communicating? Are you with me?
Yes, sir.
All right, good.
Yes, sir.
All right, thanks so much for that response. Then I mentioned earlier that the contract actually we have trade base, we have equity base, we have lease, we have issue of actually debt, and we have services. So let me start from the trade base. The first item I'm going to discuss on another trade base is that just to give short definition, and there's pictorial, something I will show later for us to be able to understand it better. But that notwithstanding, I still want us to note down and ask questions that area, the gray area you don't understand. Murabaha, I said this can be defined as a cost plus profit sale transaction, in which the seller must disclose the cost price of the goods and its markup. You underline that something now. I said it's a cost plus. From the definition, that is the cost. We had the cost of the item. We had our markup, which is the profits to that particular cost of the item. That's what they call actually by Muaba. They call it actually a credit sale. If you want to pay, by the time you are paying back, you understand, you can actually be able to pay either through a bullet payment at a future date, or you want to be paying instrumentally actually, as the case may be. Please, what you actually want to do. But what is most important is that at the time of executing the contract, the price must be agreed at that point in time. And I mentioned that what led to the price is the cost and the markup. It is not, that's why it's called Murabawa. But if it's Musawama contract, which is what we are not going to that actually today, the Musawa, if that's somebody just approach a granite seller or somebody actually on the road that actually or somebody, a car dealer, just go there and be able to just buy directly. That person is not under any option to say, yeah, I must disclose to you the cost price. But because he is in Muraba, you understand, it's not that in most instances you don't have something down. It is based on request from me as a customer. Let's say, for example, actually in a bank, you approach actually a bank and now tell the bank that, yes, like I need this actually item, I need a cow. Can you buy that actually, for me, and I want it actually under Muraba, and I say, okay, bank, based on your promise, say you want to actually, the bank actually will now come, and that's why the promise is actually from you. The bank actually will now decide to go and actually to buy that particular item. But in the instances that the bank actually had the right to request for security actually deposit from you, because you promised that what if at the end of the day you do not you back out later that you don't need the item after the bank actually your certain actually expenses. That's why from that deposit, then the bank actually will deduct whatever actually they know. If supposing you back out, I said the price must be agreed between seller and buyer before a Muraba contract could be executed. I said there are two variants. The customer might indicate a promise to buy an item from a bank before purchase, or he just approach the bank directly, and the bank is at liberty to demand a deposit, which is called Amisel Dia. There are other kind of deposit that we call earnest money, which is arbon. We are not discussing that one actually today. But let's, for it to be clear, well, I actually assume that I don't want to assume that everybody here actually are Islamic finance actually professionals. That let us have because that's where we are also trained. You have the fundamentals too. Gradually, you keep on actually, graduating and know more about all this actually contract, but just want to know the basic. Then the second one actually is under the trade base we are discussing is Salam. I said this can be explained as a forward sales contract where buyer pays the full price of the goods upfront, but the goods will be delivered at a future date. This kind of actually contract is being mostly used for actually agriculture, but it could be used for other products too. Because why agriculture is more pronounced is that this was the contract Rasulullah, our holy prophet, sanctioned for them when they go to Medina. The people of Medina, majority of them actually are traders there. What they do then actually is that the dates, which is a common actually agricultural product, they normally sell to themselves. But Rasulullah say, okay, you normally sell. Somebody actually when they sell actually to each other, they sell actually on credit. I will pay later, and even some will not have even see the good sell. You understand? They will now start selling. But you now advise them that the arrangement you are doing, you can bring confusion. The prophet is somebody sent by Muhammad and said he's being sent as a Messiah. He understand, to all mankind. He's being sent to be able to actually to put Rama in our affair, to guide us. He said, Allah said he has sent actually in Surah to actually and be has sent him actually as a blessing to the entire mankind. So immediately he got to Medina, he said, the arrangement you are doing, you can bring dispute to, because there are instances where somebody will say, I have a date in my farm. I've sold to you. So meanwhile, the person who bought the date too have not even seen the date. He has sold to another person. They after all, Mr. A or Mr. B have told me that I have sold 20 tons to me. So I can give you 14 tons out of you, So because you can bring this put actually there. So, but meanwhile, where somebody actually approach a bank because Islamic actually bank actually expect that whatever actually want to do, it must be fiscally present. If you recall what we discussed earlier, that item of purchase must be fiscally present. You must be able to actually, and for you to deliver, it must not be subject. But this is an exception as far as Sharia is concerned. And actually, and Sharia certainly because it was actually practiced during the time of Rasulullah and it was not terrorist. But he stated those conditions that will make it not to bring dispute. I said this type of sales must meet certain conditions. One, the kind of item that you want to actually to be able to now that will follow that salam must be something that is homogeneous goods, that is goods that is generally available. Then dates, the audience very, very available actually with them, that in the market, then both the price, quantity, quality, time of delivery, and place of delivery must be agreed at that time they are contracted by parties. Let's say for instance, I approach an Islamic bank, right? I said, I am a producer of watermelon. On an average, I can do 10 tons of watermelon. And the bank now decided that, okay, good. If you are going to be able to now do 10,000, okay, let me see the example of watermelon you normally produce. Because he has some in stock, he brought them. He has done actually able to see. So at that point in time, let's say the market price at that time actually that each of those items cost let's say 2 naira per one, and we are going to almost 10 tons. But because the person is not using his own money, right? Being an agricultural product, there are chances that if it's not that there is a lot of harvest about the same time, chances of price actually be now going down might actually be very narrow. So the bank will now say that, well, you are not using your own money to trade. It's my own money. This is the amount I'm actually I'm going to buy. And the person after calculating, okay, because he's been a farmer for years, been doing it. When I buy seed, when I do something now, it's just like the person is sharing part of his profit. He knows that all the item, factors of production, everything put together, his effort and all this something. That's okay. But actually everything is being done, it might cost 1 naira 50 kobo. So now say this 5 naira that is on that the 5 naira that is actually on top, which is his own markup. That is what the person is sharing part of it actually with the bank. The negotiation will now come. The bank will now say, instead of said that 2 naira that is being sold, like we sold at the market, I can't buy it. I'm going to buy it since I'm actually for me. I'm going to buy from you at instead of 2 naira 1 naira 80 kobo. But the person knows that if everything you're going to put together is with the expertise is 1.5, with 1 naira 80 kobo, you see having 30 kobo and she's at your own profit. So you only want to give bank part of the something because it's bank money you want to use. Meanwhile, because it's an expert, now I agree. Bank will now advance money. Because if the bank does not advance money to that farmer at that point in time, the purpose is being defeated because the benefit that the farmer is supposed to have will not have. You understand? And it's the same thing if somebody that want to supply actually goods will not have that benefit. At that point in that time, you don't have that point if you also now defer, the payment. But however, it's only the delivery of that particular item that is being being put at a official date. But meanwhile, you will have agreed. And Rasulullah specified that if you must do that, you make sure that you agree the price, the quantity I'm actually giving you at the official date, the quality, what time am I going to deliver in 3 months' time? Am I going to deliver in 4 months at the particular? Yes, must be actually be agreed. so that in case anything actually, why is the opportunity that in case anything actually happen, maybe because anything produced from a farm, it's not man-made, it's due to nature. If you eventually actually, it did not come out well, the person should be able to find and use another money to go and buy the same item and deliver to the bank, so that you meet actually the quality. Because you will see instances where I will show you instances where something actually is very necessary. Because most times, the bank too, they are not the one when they buy the watermelon, not that they want to keep it. They will also engage in another contract, which you call parallel salam. You will see that one later. I will explain to you that they will quickly want to actually to sell it, to another party. But the two must be separate too, because the bank that is engaging in parallel salam cannot tell whoever is his buyer in that other one. In the first transaction, the bank is a buyer, and in the second transaction, the bank is now a seller. He can't tell the buyer that his own supply of watermelon to that buyer is premised on the condition that the first seller sell to him. Sharia does not allow that. That's why the two must be distinct. They will be separate actually contracts. It's a different one. That's why those conditions say that, because that person must perform whether he likes actually or not. That if your produce does not come on well, you go and actually buy back in the market. And as far as if the bank, if you're supposed to deliver say by June, and the bank actually have another parallel seller to deliver in July to a third party, if the other one fails, the bank must make sure that what he promised the other person, he also must produce it. All right, that's under the parallel salam. I'll show actually the picture something for you to help you understand. I think from this explanation now, when they say salam actually is that future transaction that you can get money now and deliver at a future date. But however, the parallel one is that because you as a bank that is buying the watermelon, you don't need the watermelon to keep to destroy. You are also in business, because Islamic banking is about trading, buying and selling. It's not about using money to just say I give you money and whatever you use the money to do, I don't care. You can see the effect of the trading activity that will mention that is what Islam is about, and we see that it reflects in the real economy and its asset base. The asset we are talking of actually here is watermelon, and at the same time, bank too, they engage in trading, because by the time they buy, as they are buying the watermelon, they are not buying trying to keep. If they agree with party A to say, okay, come and deliver to me by end of the June, the other party B, which they engage in parallel salam with, they tell that person, we are going to deliver by middle of July to that person. And meanwhile, they will have added their own money to say, this is how much I'm selling to you, so that they are not at a loss concerning actually, the transaction. Then another trade-based contract we have is now. But it now is also will make that the other one is made on the other one salam will discuss we discuss asset that is goods, fungicide goods, something that actually can see. But however, under Isisna is for manufacturing. A manufacturer, this is for goods that is not actually on the ground. They are similar. One is for actually agricultural base, while the one is going to be an individual that will construct it. That will construct that item. But meanwhile, the thing also is not at that point in time you give the person money, but because it's a project that you have the option to assess its stages of completion, I will not be advancing money, unlike where it's for agriculture that you advance the entire money, for that actually, to be produced. You are not saying that okay, you want to first clear the land, take money first. No, all the money. The object is that what we are selling to you is watermelon. But under Isisna, it is a contract, a project, or you can even be, say, a searching in your room. You can engage a capital, somebody actually, okay, you want that to actually engage, it won't be a manufacturer or something. But you now approach bank that you will need actually money. But meanwhile, based on what the person do, you will now be advancing money. And you can actually advance money over anybody and say, okay, beyond buying actually the material, give me the entire money. but it will be delivered. The person is getting money, but item will be delivered actually in the future. Then the third item to discuss here actually is called Tawaruk. Tawaruk might not be common actually in Nigeria, but although it's what is accessible to, but most common actually in Malaysia and other Asian countries, because they started Islamic finance actually and Islamic banking actually before us. And this is otherwise called because it's what I call monetization. If not because a lot of actually banks actually Islamic bank have been engaged with it earlier. You know, there are so many actually the IOFI, which is the standard setting organization, will actually be able to ban it because there are an abuse or several abuses come with this one. What means actually is that somebody actually needed money. You know, let's say somebody he has, you know, maybe could really be feeding or to take care of something actually in the house, which is not something that is actually tangible. That we cannot say, okay, bank, buy this item for me. The person now approach the bank. You understand? It was first used to replace, be used in place of Muraba before, until when they now discovered that it was being abused. You know, because it being abused is just that a lot of money is being diverted from it. Somebody will just whether what the person does not even need will come and lie to the bank to say, we need the cash actually, you know, you need money to meet certain actually expenses actually in the house or something like that. And what they do in Malaysia is that they have an organized market, and the product asset they use on this one is that they use palm kernel fruit. You know, it's what actually they will be able to say, okay, the bank actually will buy. They will buy from, just like we have a stock exchange. We have Nigeria. They also have stock exchange. On that, they have more financial and they have commodity actually market where item can be sold. You know, physical item, not financial actually instrument. You know, can be sold based on actually tons. We have this here. We want to sell it and everything. So based on that, so that was what formed the basis of the item that they are selling. However, during the time of Rasulullah, because that's why I put classical view and contemporary scholars view, so that I'm able to actually to explain it to you, which is what as far as Sharia is concerned. Contemporary, the classical view actually is that I believe that whatever I cannot come, because before there are even instances where they don't even allow to sell commodity to that person. That person will go and bring something from his house, bring an item. You understand? You want to bring an item actually, you know, actually from his house. He said he sell to the bank, and when he sell to that actually to the bank, and maybe he sell to the bank actually at say 200 naira for example, but because he doesn't, what he need is money, the bank will now sell the same item back to actually to the person at 220, so that they now stagger the payment. But when you view that, you will discover that at the end of the day, it's actually the money the person is being collected, because it's the same person that brought those items, you know. But the classical view of Sharia scholars now say no. You understand now? That if this person is the one bringing that asset, then at the same time you are just actually giving the person, you should be. It has violated Sharia principle that says that the item you want to sell as a bank, you must own it now. You understand? So you must be the one that will be in capacity, that not from the same person that you want to give. So that means there must be three parties. So the bank will now actually need to now engage a supplier. Go and, okay, I want to buy this particular item. So it is that item they will now buy and say, okay, when they go to the organized Tawaruk that they actually have in Malaysia, actually they go to that, how much is a ton of palm kernel food? It's actually maybe 1 naira. The 20 tons will give us actually like 20 naira, for example. The bank will now buy it. They will now sell it to the person that need money. That I bought it at this one, and I'm actually now selling to you at this particular, you know, rate. So, but meanwhile, because bank does not want to be seen to be the one that release money to that particular person, you know. So bank will now be like that. By the time actually they bought that particular item, you understand, they actually have it now. So it is that item that the bank will now give to, instead of giving the money to the customer, they give that particular item to that particular customer. Yes, sir. But meanwhile, the bank has bought it for example, I say 20 naira, for example. But they know that by the time the customer has that palm kernel 20 tons, he understand. But the bank is selling, bank bought it for 20 naira, but bank has sold it to the person at 22 naira. But when the party has the asset already, when they now want to sell to a third party in order to obtain money, you understand? You know, the third party will buy at the market price. The person will not buy at the 20 naira the bank has bought. So they now buy at 20 naira. But the customer that needs something will have already gotten the 20 naira. Meanwhile, he will now pay either in 2 or 3 based on whatever you agree with the bank, installment payment, or you want to be a bullet payment. But because the item that was sold to the customer does not need it, that's why they call it monetization. You understand? Do you understand the gist? He did not need that particular item, but he just needed to collect money. But because they want you to be to comply with Sharia, you understand, that item will be sold, you know. But what he did, that's why I often said it should only be done only when it is very, very much necessary. You know, they were even trying to see that if they can actually cut in that trade, because they see that a lot of abuses actually come. You know, people come, a lot of people, the item they do not need, they don't have actually cost to it, they just have, and at the end of the day, they sell it. And they now find it difficult to pay the bank's money. So a lot of credit issues are now coming up. You know. So the next thing I'm going to discuss is lease-based contracts. I itemize just 2. Yeah, which is just Ijara and Ijara Mutaya Bitameleke. So by Ijara, I said this is just a lease-based transaction. What this means actually is that somebody who has an item, you now lease, you now become a less, you own it, you now become a lessor. Somebody needs. For example, I can buy a car and I decide to say, okay, I want to lease it to somebody, which the bank does. You understand? The bank answers, okay, the person says, I don't have the money to do that, but I'm an expertise, I'm a driver, I have the proficiency or something, I want to be able to now, you now lease to, you know, but you now say, okay, you'll be collecting rental, you know, whether on a monthly basis, you know, but you are the one that actually, you know, own the asset, yes, but you lease to that particular person. So it's only operational something, especially that the person will go. But major thing concerning that car, it is your responsibility because you are the one that owns it, you know, at that point in time. But over time, it can be for 1 year on a monthly basis, it can be for 2 years that the person will pay back. Then the second aspect of it is that we have Ijara Mutamaliki. That is, the person is the intention that is listening is that you want to own it. That has been agreed right from the onset. It's not a decision that well, when I finish, you actually pay your money. I don't need your car. Tell you, okay, the car value, you can take your something back once actually you buy it for me. But however, the other option is that I have leased it from you, but intention to already have understand that I want to own it something at the end of the day, you know, that will have been agreed. But it's also a lease, you know. But whatever actually is left, you know, as part of the residual value, you know, some of us that if you have not even worked in bank, we'll do something that every asset will look at their useful life and now start doing amortization. So at the end of the day, we always have actually residual value that what is left, you know, whether it's 10 naira or something like that, but somebody can still say at the market price, you know, based on actually the item. So that's what I mean by that. That is the second aspect, that you are leasing, you lease the item from the lessor, but with intention to own. Then the third one we want to discuss is the partnership contract. Here we are discussing Musharaka and Mudaraba. I say Musharaka is a joint venture where partners contribute capital and share profit and loss according to pre-agreed ratio. What that means actually is that 2 parties can come together. We want to engage the actually. It can even be 3 or can be with 4 parties. We now contribute money. Okay, we want to actually establish a restaurant business. You understand? Contribute money. Then whatever profit that comes actually from this, you understand? We now be able to now share. In fact, either of your member of the parties can be even engaged as a professional. to say, okay, come and be working maybe as a manager there. If he has the expertise, but it's not mandatory, you know, you have good capital together, and at the end of the day, you share, you know, you share by the profit, you know, and when there is loss, you also actually share it, you know, actually together as far as the joint venture actually is concerned. Then let me quickly discuss the other one that relate to this Musharaka too, which is relate to the what I've discussed under the list as well. You know, you also have counterpart of Musharaka Mutabaliki. What that one actually means as well is that both the bank and an individual, I can come to the bank now and say, I saw a particular house, I want to buy it, but I don't have money. I don't have enough money. I don't have everything. That's okay. We can go into a partnership together for us to be able to buy it. Let's say the house, for example, that building costs 100 million. And I say, well, bank, I can only afford 10 million or 20 million as the case may be. The bank say, well, I value that particular asset, everything. I don't mind. I can go into partnership with you. I will give you the remaining 80%. Yes, sir. Add it together so that you can give to the owner of selling the but we now have a partnership actually agreement. Meanwhile, it is possible that me that say I saw a particular house, I might be the one that say, okay, I want to use the house. If I'm the one using that, the house, you know, in the first instance, I'm not the only one that owns the house. It is both joint contribution between me and the bank. If I must use the house, I must be paying rent. And it might be that the house I'm also buying is for business basis that I'm not using it to. If for somebody else, is for us to now list out for somebody else that will be paying rent, but it must be generating money. So it is that rent that is being generated. Yeah, from the rent that is being generated, you first actually pay the cost of funding the bank 80% that they are provided. Then the profit that is there, two of you now share it based on your capital being contributed. And meanwhile, you also, from what will be shared to you, you will now be, you know, paying down. The bank was owing 80%, was financing for 80%. You now be giving the bank, you now be paying down bank actually facility, not only actually the profit. You know, you want to be paying actually the principal gradually. So as you are paying the principal, 80% contribution by bank will start reducing to 78%, 70%, 20%, until you are fully paid the bank actually money. So that's why they call it joint venture actually partnership, that you come together. Before it was after that one, then the house will now become fully yours. You have actually brought together at that point in time. So you both own the property, you know. Then the second aspect under partnership that we're discussing actually is that I just quickly ship in that particular one to know that there's another variant of Musharaka too. You know, I try as much as possible not to overload you, so that I want us to be growing organically, so that we can actually understand all these principles. But as time goes on, gradually I will be going to you to discuss with you Sharia standards, you know, and relate to those items, so that you'll be able to, you know, come out and talk actually professionally. This is what I always said. This must be present. This must be there, you know. Inshallah. The second aspect is Mudaraba. By Mudaraba, I said it's also a partnership. We are one party. I mentioned in your last week that a Robuma, at least you are the provider of the capital, and the other party, he has an expertise. He has to be able to say, let's engage in this business together. Let's say, for example, now somebody said, I am a driver. Now come and approach you and say, let's come into partnership together. You now know that, okay, you have a means, you can provide the money. He has done for me. When I say, okay, we sign an agreement. It's a Mudaraba partnership agreement. We sign together. Okay, I'm going to buy this car. I provide money, the money that will be used to buy the car. You understand? And it's you that you will be using that car for an investment. You understand? And it's possible for me to just provide the money. It's you that will now you are use money. It could be other investment. It might not be car business, can be other business, but that business you have the expertise, and that's what we are contributing. And we now agree that since what you are contributing is expertise, I'm the one that contribute money. Okay, when supposing 100 million every month or every 3 months, let's say 1 million come as profit. Okay, what will happen? I will take 80% of that 1 million. You will take 20%, and it has been agreed, it has been documented. Yes, and no, you are a robber money, provided money, but it's the one managing it. Yes, but however, Sharia say that the person cannot guarantee your capital for you. That if the business does not go the way we plan it, that I must go and provide, give you back your capital. No, it must not be guaranteed, because what is dealing with is a business is only Allah known who knows when business is going to be profitable. So you must have it that you guys are partnership. You are sharing risk and you are going to share both profit and loss. The same thing too, it can actually happen in bank too. Yes, and we are customer. The customer can walk in and I say, I'm not depositing money under Wadia as safe custody, but I want to deposit money to you, a bank. Use it to trade. And whatever the money that comes, you understand, the profit that comes out of it after trading, we'll share it together. But unfortunately, we normally have challenge concerning this. That's why the issue of the most of our banks, going to savings accounts and the rest, guarantee profits to customers. Even some of them even went have guaranteed capital too, that they must give it back just because they want to show that they want to actually align with confessional. But if you must practice Islamic banking specifically, as Allah actually ordained and as Rasulullah actually stated it for us, gave us those conditions and principles. Capital must not be guaranteed, and why profit and something also can't guarantee profit. It's only Allah that knows whether business is going to be profitable or not. But two of you are only just you are taking risk, which is what Allah says that we should take risk as individual. Because if you don't take risk, you just remain stagnant. Say we have to strive, put our own effort, and that effort that Allah will go to reward. So, but however, if it is proven, which is the area some of the banks actually rely on that since there is a caveat, that Islamic Bank says, I'm the one that advertised now. I say I have the expertise to manage money, and I have told that somebody that once you give money to my bank to trade with my expertise, so I should be able to give you certain amount actually as profit actually to you. So the bank actually decide on their own that yes, for that money for the capital to have gone, then that his expertise is being questioned. So in order not to start even query that, because Sharia says that if it's proven that the mudarib is negligent, a gross negligence is being proven against the mudarib, which is the person that you give the money to, that person must provide the capital back to you. So that's why you see some of the Islamic bank already, what they do is that when people come and they will say, okay, based on their normal profit rate, normally generate from this kind of investments, you just give a particular customer a particular benchmark rate and say this is what I want to give you. But these are part of the Sharia issues that will normally come across under Islamic finance, because it's that you don't need to be, you let the person wait that if the profits come to this is what amount of profit comes is if, because you are not God, you are not a material. This is how we are going to share it. But in an attempt to win customer, that's what is practical in modern Islamic bank. Customer will not tell. A lot of customers do not even understand Islamic finance to understand that why would I give you money and they say it's only when you can I trust you to that extent that you will not tell 2 naira will come as profit, and you won't tell me that it's 1 naira that come as profit. So based on your previous experience, give me an idea of one profit that I can collect. Yes, and otherwise I will take my money to another bank. So those are actually theory, and that's for us to be able to actually understand it and be able to for it to sink. I try as much as possible to go and pick few pictorial, representation, from different actually sites for us to be able to see how those things are, so that with the picture that we believe that it will make it actually sink further apart from the theory we have discussed. Am I communicating? Okay,
Now,
good. Yeah. I want us to look at, I hope you can see my screen very well.
yes, sir, we can see.
All right, good. You will see that on the vertical side, we have picture of a bank, picture of a supplier or a vendor, then picture of a client, which is a customer of a bank or an agent. So based on what I've explained, I said, and now under the horizontal one, the first one will have a master muraba agreement. That is where, and what normally lead to that master muraba agreement is that, I said, a customer of a bank come forward to a bank. He has started to say, please you go and buy so item from you, for me, whether it's car or battery or book or any item. I promise you, I'm going to buy from you. Then the bank will now execute agreement and say, I promise to sell to you. So that agreement now come. You understand? So both parties now agree. Okay. The bank say, I promise to sell. Then the customer now say, I promise to buy from you. You know, if you observe very well, you will see that the customer of a bank is being given dual role, client and an agent. Did you see it very clearly?
Yes.
You're good. So, because there are instances where the bank, because they don't have the expertise, instead of saying, I'll tell you, they will now say, okay, yeah, maybe this customer, this product you need now, you have been dealing with it, let's say for a very long time, okay, good. We are appointing you as our agent. It's a customer in the first instance, the client to appoint you as an agent to go and buy this item actually on our behalf. But meanwhile, they will not give the money to the customer then, so that the customer will not say, I have gotten the money. The customer, because of his expertise, will now go and approach. Supposing the customer want to buy, I say it's a generator that I say he needed. Because I say, okay, will now go and get invoice. You understand? But you know that actually you have to go and get actually from a supplier who is well known, who know that, and bank is at liberty to go and verify to say, is that supplier, is he a reliable supplier? Yes, not that the bank, because you appoint an agent, you now decide to just let me go and tell my brother that you can supply, just bring the invoice. No, when you bring the invoice to them, they give you that privilege because you are being in that business. You understand? And from day to day, something experience, you will have known that this item I need you. The supplier that sells original is so can be one, it can be two. The bank will say, okay, go and get the invoice for us, or the performer invoice and the rest. They actually get for them. And by the time actually get, it's an agent at that point in time. But meanwhile, bank, you see that the next stage that the bank actually now obtain the first, they say under the agency agreement, they execute with the customer. Is the bank is acting as the principal, while the same customer is acting as an agent. Am I communicating?
Yes,
Are you with
sir.
me?
Yes, sir.
Yes, sir.
All right, good. All right. So, but meanwhile, that product at that point in time is the bank that is buying it. You now see that the bank, under the next agreement, purchase and payment of the purchase price, the bank is the buyer, while the supplier or the vendor whose invoice was gotten, by the customer, is the seller, and the bank will now pay directly to the seller. But meanwhile, that item will be delivered to the agent, because the agent is one that went there, and that agent double the dual role of both client, both agent and the customer. At that point in time, it's holding that something in trust for the bank, because he's not the owner, because at that point in time, no contract has been executed between him and the customer. That time to say, I have sold to you. So it's only as an agent. And based on that contract, you is just helping the bank to keep in custody. The bank can say, okay, come and return to me. But bank can now look at if you return to me, if I want to return back to you, operational cost will be actually on the high side. Okay, let me keep in your warehouse nothing must happen to you to it or something like that. It's an agent, and you must not put it to use. That's what you see. I say that now next day. Then the bank will now, execute offer and acceptance actually, agreement. The bank is now the seller now because the bank owns the item now. The item might be in his custody or be in the custody of the customer. He owns it as the seller because the receipt, he has the performance invoice the first time, issue in his own name. When he paid, he has the final receipt issue in the name of the bank. He's still the owner. So it is that something that item that the bank will now sell to the customer now based on an agreement that will be offered and the customer will now accept. So you can see that the first stage is offer and acceptance. Bank being the seller, while the customer now being the client. Yes, the customer now actually now from agent now turn to the buyer. It's when you now buyer, the something that at that point in time, you now become materially his own. You understand? So at the time they are executing that offer, then a Muraba actually agreement, payment of price, Muraba price now become binding on something. So it now bank become the creditor while the customer become the debtor. Have I communicated?
No.
All right, good. Let's quickly discuss the next one. So that I purposely went to go and get some of this so that at least before we leave this webinar, we actually have practical knowledge and be able to actually grasp what we are discussing. We'll be discussing theoretically earlier. So I went to actually that another one I capture is which is also on Muraba 2 as well. You have actually a third party too as well. You see when you look at the way something not example of here where we say a microfinance actually bank actually institution, we also have actually a supplier, and an invoice is being gotten, which is the same thing that actually are related to that when you get actually the invoice, you are acting as an agent for the bank at that point in time, and you are just keeping it. But it is that vendor that money will be paid to. You see that the same payment is supplier name, they pay to that time, but the bank actually doing actually as an agent, for the same product actually want to buy, and either the item has been gotten, then the bank will now sell, the same thing to the customer back. So this is what this one also has explained. Then which is also on Muraba we just discussed. But just let me have two so that at least with the picture it will sink very easily. Then on Salam, I explained to you earlier that when we were discussing actually theory, that Salam means that is paying for goods and advice in advance, but delivery will be in the future. And I said Salam is one of the exceptions allowed. It's Sharia itself that allowed the exception, because when we were mentioning contract, that time form of contract said the goods must be present, the person must own it, must be capable to deliver it at that particular time. But as far as Salam is concerned, it's Sharia that excludes it. Rasulullah actually sanctioned it, that actually is being allowed because it's a way of assisting merchants, traders who has expertise in the business but does not have money. And it was being practiced, just as I said. Rasulullah met them when he got to Medina, that is being practiced, but he does now give certain conditions so that you not give to dispute. If I want to explain this something, just like what I've done before, so we have, this is a good that the customer says yes, we can deliver. We signed a Salam contract with a customer and an Islamic bank. You can see the flow. That the flow is between, in the first instance, the first flow is that both Salam, both customer and the Islamic bank actually they come together. And the customer says, I'm going to deliver. You can see what is displayed there is like more picture is like in bottle or something there about. What do I need from you, the Mr. Bank Manager? I have been dealing with dates, or I've been dealing with torchlights, I've been dealing with books, I've been dealing with social items actually for years. I always that. You now approach the bank. When you get to actually the bank, you can see that the item is displayed. So both the customer and the bank will now actually agree. Okay, this item you want to deliver to me. What is unit price? We'll note it down. What is going to be how many quantity are you delivering? We'll note it down. What is the quality? Color. What is the specification? If you ask the specification, you ask, my specification is this one. It has to be golden. It's going to be made of metal. All those descriptions there. Where are you going to deliver and what time I'm going to deliver this something? Okay, we now talk of the price. Market price is 2 naira for this item. That's okay. But now that for you to go and buy it now, it's my money you are going to use it now. What's my own bottom? Okay. Also, I'm going to pay you after I finish selling, maybe in 3 months or 6 months time or something like that. Okay, no problem. Instead of actually 2 naira, you can give me. I can sell for you for 1,000 for 1 naira 70 kobo, and they execute a salam contract. Then the bank advance money. Then the customer actually go everything after those things actually are ready. Then the customer, you can see the arrow too, that the customer now go and later go and deliver that goods yesterday to the Islamic bank. And don't forget, when we were discussing the forms of the contract there, I told you certain condition must be met. The kind of goods that you can do with this salam contract must be goods that is homogeneous, goods that is readily available. If peradventure, you cannot actually do deliver, because I told you that this other the bank too, the bank is into business of finance. You understand? They might not have a store where they want to be keeping all those actually items they purchase. So they will quickly want to go and enter into a parallel salam with another person. But that parallel salam, just as I told you earlier, must not be made as a condition that it is only when my customer deliver on the first one that I'm going to deliver. If they specify that one has nullified the salam, the parallel salam actually contract, they are distinct on its own, because doesn't want to know, the other party doesn't want to know that where you want to get the goods for, whether your customer you give him money is the one that will give to you. No, it's not the person's business, but it's you that know that if my customer says that I give money to say end of June I will bring it, you now say the other person by first week in July I'm going to deliver to you. But if he fails, it's your own problem for that engage the parallel salam to go and make sure that you get that particular product, so you can see the flow. So how it runs. Then for the parallel contract is salam is what I've actually also show here, that where the bank would go and actually engage. In the first one, the bank is a buyer, while the second contract, which is parallel salam, the bank actually acts as a seller at that point in time to sell to the other party, and when they are selling something, they want to add their markup. So, and just to confirm that and prove the point that what Islamic banking is all about is about trading, buying and selling. Yes, and what they are buying and selling are commodity, not money. Money is being regarded as only a medium of exchange. It's not being treated as an asset, unlike conventional bank. So I see, illustrate further under parallel salam for us to be able to understand here. I said, let's assume that Mr. Ahmed entered into salam contract with Mr. Bashir to purchase 1,000 bag of wheat and it's 100,000 per bag to be delivered in 12th of August, right? That is the salam contract. You understand? Then the same Mr. Ahmed who wants to buy wheat from Mr. Bashir decided to say, okay, I want to act actually as a seller now. You will see that in this contract A, you see that Mr. Ahmed is the purchaser, he's the one buying from Mr. Bashir, who's a seller. But Mr. Ahmed now go and enter into, we are not using bank and practical something like Mr. Khalid. I want to sell, it's the same product you want to sell you, but it's not the problem of Mr. Khalid, whether the other party deliver or not, which price. He got it at 100, he now say I want to sell it to you at 105. But meanwhile, instead of, because he cannot put on the same day, 20th of August, he now puts so that on 21st of August, I'm going to deliver to you. So at that point in time, you see that Mr. A is actually, Ahmed is actually a seller, while Mr. Khalid is the purchaser there. I hope I've communicated. Are you with me? Salaam alaikum.
Now we are with you.
All right.
Walaikum salam.
All right, no point. Then it's still that too, just like we actually explained. I said that one actually relate to manufactured goods, you know, where a manufacturer, you know, actually approve actually the bank, then the person who go to manufacture that particular good will be advanced money, you know, as actually, you know, is progressing, you know, and he also is related to salam, but the difference actually between this one actually and salam is that one actually did that with all good, but this one did that goods that are being manufactured. That is just the major difference. You understand? You know, it's just that it's being manufactured, and there's no, you have your under this this is now you have the option to be paying the manufacturer as if he or she progresses in the manufacture of that particular item. You understand? Unlike the other one, is the full amount of money you give under salam, you know. But the whole thing is that somebody is collecting money in advance after he has actually done what, you advance another money, and it goes like that. Okay, this is also it is now trying to actually to explain, you know, how the sales, you know, that somebody actually be able to now buy. Then the other one that then easy one, so you can also engage in parallel one, because the same item that's going to be delivered under that by the manufacturer too. You understand? The same bank too, you know, who has actually engaged that partner can decide to say, okay, go and engage in another contract with another party. But the two are independent too, because that's one of the Sharia conditions. You must not tie salam and parallel salam together, and neither can you tie istisna and parallel istisna together, because they are two independent. Once you tie them together, it has nullified that particular contract. They must Sharia says there must not be two contracts in one. It should stand on its own, and one contract should not be a precondition to the other one, you know, or else there will be dispute and dispute. Because, for example, now, assuming a parallel salam contract actually is being tied to salam. So once the salam material, you know, say default, parallel salam also, so I have reason now. After all, this other person has defaulted now, so I also defaulted. Maybe the person who is also the buyer of that particular one has a particular place too where you're supposed to go and deliver particular something, he also will be defaulting. But Islam does not want any dispute. It doesn't want somebody to have and it might be that the fourth person on that salam is the one that is dubious. For example, it might be the one that will be dubious, that collect money and use it to do something else. And because can you now see the shame of default that will go? That's why Islam says whatever you are doing, no contract should be a precondition to the other one. They should act on their own, so that you deal with this one. So you that is on parallel salam, by the time this other party, that's why you are relying on the product from that price. Once it default, you have the responsibility to go to the market. That's why one of the conditions is that the goods or an item under salam or artisan must be something that is easily available in the market, so that you don't default, so that there won't be crisis in the society, you know. So then ijara, the example of this one actually I got actually from ijara is that the bank actually, you know, purchase an asset, which is actually the first one. And you know, the other one, when we were discussing under the theoretical something, I used actually the issue of a car. Okay, yeah, they have actually used, you know, an asset which is which the bank actually is used here is that they use, which item did they use? Okay, well, it is something that is being covered. An item is being bought. Yes, and the bank paid the purchase price, and the bank now lease the asset, to the customer who had requested actually for it. Based on usage. It might be that maybe for this something to cover, and maybe it's a photocopier machine. Somebody who now operate a business center will now be using it. Will now say, okay, I will now be, based on the deposit is being generated, will now be paying rentals, over time until he pay down. That's what we mean by actually under on the ijara. And I gave another variant of ijara is that the one we have, just like we have I say we have ijara mutakasila bitamilik, where you have bitamilik, as you want to own, it means ownership. where you actually have the that I am listening to this particular something from you, you understand? And I want to, with the intention of that, I heard of it, I want to own it. You understand? That contract will have actually been executed. And let me just digress a bit for us to understand. And some of us must have heard that in Nigeria, between 2017 and last year, this year, the federal government of Nigeria had issued sukuk worth over 1 trillion naira. Are we aware? Do you know what
Inshallah.
Yes.
Yes.
You will know that the structure, the contract that sukuk follow is on lease arrangement. Although the money they use that something to construct roads, they use it. But because investors, those of us that are invested in that particular sukuk, who invested in Nigeria, we are the one that own the assets, that owns the road. But because you don't have the expertise, most of the federal government also did not want the road to be towed. But we now decide that we'll lease it to the federal government. Say, okay, you have the expertise, be paying renters to us, assuming that federal government will tow the road and be collecting toll gate. But because federal government has realized that we have not provided enough infrastructure for the masses now, we can't afford, and a lot of masses are already impoverished now. We can't afford to tow the road now. We're supposed to provide enough. If supposed to provide one, so if it's alternative now, say if there are certain roads that people can pass, like 2 or 3, we now construct a special one that instead of spending 30 minutes, you can spend 5 minutes. If you try to tow that one, we'll know that that one is a special one because you have provided the necessary amenities actually for the masses. But whoever now wants that, I want the one that I will pass in 5 minutes, so I must be able to pay a premium for it. Yes, and so that's what we do actually under it is the general contract that they finance the road construction. Investors come together, they are the one that they use their invested money, the SPV, the special purpose vehicle, that act actually on behalf of the federal government, which I take company from. They are the one that collect that particular money, and through the assistance of the Sharia, they now make sure that this asset you own it to, and I must make sure that you get back your money back and your renters. They now give the road back to the federal government under lease. Then the renters, federal government will now be paying the renters to them. That's why we see that the renters of every 6 months that they pay to them, And you see, we are profit rate of the last one was almost 20% profit rate that they give, And at the end of the day, the federal government will now buy because we lease that because the federal government is the one that owns the road. But legally, investor own that particular road because they are the one that use their money to purchase it by way of actually investing. They now sell the road back to the federal government because it was on lease before. The federal government now pay, the full price. What they are paid earlier on a 6-month basis actually is the rental, which is the profit, and they now pay the full back, and then the contract now becomes like distribution. So that's why by the time we get to actually Nigeria under Islamic capital market, you actually appreciate that. But I don't quickly ship in for you to know that a lot of activity has been going on as far as Islamic finance is concerned, so that at least we can sensitize ourselves and sensitize people around us, that we as Muslims, that we have a lot to actually to benefit if we are not been showing interest before, that things have been Islamic finance actually is a better alternative, and you can see that those roads being constructed now is now being useful to everybody, every Nigerians, be foreigner, be Christian, be what you attend, which is why at any point in time we should be able to say confident that Islamic finance is a better alternative than conventional finance. Thank you. I hope you will agree with me that with these various contracts, with the Islamic financial contract, it is a better alternative. And thank you all for listening.